Good afternoon, everyone. My name, your humble host, is Benson Okezewosu, Esquire. Welcome to another session with Asset Debt Recovery. And the topic for today is a very simple one, actually. But we deemed it worthy of note that everyone should know this: debtor, creditor, and literally everyone alike. And the topic is simply the rights of a debtor. Now, here at Asset Debt Recovery, our mission basically is to help everyone get out of debt as much as we can. However, we still go the extra step to enlighten you on certain key area of this debt recovery journey that everyone needs to be aware of. Thus the topic, the rights of a debtor. Now, we all know the general practice of how debtors are mistreated and how, they are looked down upon, stigmatized, discriminated against, and basically all sorts of maltreatments simply because you are owing money. So the essence of this session is to enlighten our viewers. Now, you heard me right. I said our viewers. I did not specify debtor. I did not specify creditor. I did not even specify you who may be owing, who is free of debt. The essence of this session is for everyone to be aware that these rights exist. So now, what are rights generally? I wouldn't want to be that person that would use a word to describe a word by saying things like rights are those rights that human beings are. No. I won't do that. However, I will use synonyms. So when we talk about rights, things that should come into your mind are things that your entitlements, privileges, things that you can enjoy, generally to make your life easygoing. So the definition that I can give you here is that rights are a collection of moral or legal entitlements or principles that people have as members of a civilization or specific community. Now, this is a very generic description of what rights are, because there's a need to know what rights are generally before delving into the main source, which is to describe to specifically highlight the rights of a debtor. So the next definition I would like to give, basic but still worthy of note, is who a debtor is. Now, a debtor is a person or organization who owes another person or organization money. Now, whenever we hear debtors, what usually comes to mind are people, human beings. As much as that is correct, that is not the absolute truth in it, because as a person, as a human being, yes, I can owe money. But at the same time, as an organization, as a business, as a company, you can owe money as well. Because companies, organizations, at least registered ones under the law, are regarded as legal personalities. And such personalities can borrow money. And when they do, obviously they don't pay back. That simply means that they are owing. So yes, owing money is not sidelined to just individuals alone. It also includes organizations, establishments, as the case may be. Now, like I was explaining earlier, debtors actually face a whole lot simply because they are owing money, they are owing debts. And usually this money spans for, they run into millions or billions. So I'm not here to repeat previous sessions by telling you how one can incur debts and so on and so forth. So I'm simply going to bring to you these certain rights that a debtor has. That yes, in as much as the debtor is owing money, there are still rights, there are still specific rights that the debtor can exercise, in the face of debt. And one of such is the right to negotiate the debt sum. Now, in this case, it is in this case, the right, like I said, is right to negotiate the debt sum. Every debtor, every person owing money has that right, has that entitlement to negotiate the debt being owed. Now, this is more like a sort of amicable arrangement because the negotiations can take different forms. It could obviously, when one is owing debt, the expectation is to pay off that debt at first instance. However, there's a reason why the person is owing that money, because the requisite facilities are not available at the moment. Thus the reason why he or she or the entity is termed a debtor. So one of the ways a debtor can negotiate, the essence of exercising this right is that it makes it easier for you as the debtor to settle, to clear your debt profile. So things that can be negotiated are: one, your payment plan. For instance, if you're only owing 1 million naira, you can negotiate with the creditor or the debt collecting agency hired by that creditor, for a flexible payment plan that will be feasible for you. For instance, you could negotiate the payment plan to be 100,000 naira per month. So that's 100,000 naira per month. That will be 10 months to reach the 1 million naira debts that you're owing. Or you could negotiate for 200,000 naira per month or 250,000 per month. The negotiation in terms of the payment plan obviously depends on the financial strength and capacity of the debtor. Now, another thing that can be negotiated is in terms of reducing the amount being owed. I'll still go with the 1 million naira example. In many instances, the money being owed by these debtors may be so much that they can't even pay it. So, in order not to, pile so much work on themselves, that's the is the work to pay off these debts. You can reach out to the debt collecting agency or your creditor to reduce the amount being owed. It could be in terms of, now this reduction could be in terms of the total money being owed, including the interest, obviously, because no one collects debt or loans without attaching interest to it. So the reduction could be: one, the sum, that's the principal sum being borrowed, in addition to the interest on these sums. You can pile them up and ask for a reduction, maybe 25% decrease, 20% decrease, as the case may be. Or you can negotiate that the interest be reduced. Maybe if the interest was placed at 10% of the principal sum every month, you can reduce it to 5%. And in some cases, though this can be very rare, in some cases you can even negotiate that the interest entirely be removed. So everything basically depends on the agreement or the arrangement reached with you and the creditor. However, please take note that the exercise of this particular right is at the discretion of the creditor to accept. The only thing this right ensures is that it gives you the opportunity to reach out to your creditor and have a one-on-one conversation to reach an amicable settlement in terms of all the things I mentioned, in terms of the payment plan, in terms of reducing the total sum being owed, in terms of reducing only the interest, or in terms of removing the interest, as the case may be. So everything depending on your approach as a debtor to the creditor, obviously that would determine the weight to which this reduction can be. So the next right is the right to dispute debt. Yes, as a debtor, you have the right to challenge a debt. You have the right to ask for a review of the debt. And there are several reasons why this could happen. Number one is that one of the reasons for challenging or disputing the debt could be that the debt being presented or being alleged to be owed by you may be different from what you have in mind. From experience, there was an instance where the creditor alleged, let's say, 2 million naira. However, the debtor did not state that there was no debt. He agreed that yes, he was owing. However, he disputed the amount. So while the creditor was alleging, let's say, 2 million naira, the debtor himself was saying that no, that what he's owing is 1.5 or even 1 million naira. So in such, obviously, you don't just make such, you don't just dispute, you don't just make such allegations at the debtor that that's not the amount you're owing without having proof, because proof literally covers everything we do in this life. So far as transactions are involved, you need proof. So if you are saying that this is not what you are owing, what proof do you have? Now, the other party, being the creditor, would not say, okay, this is what you're owing. So it's a thing of balancing the records of both parties to see who truly has the who is correct in that instance. Now, another way to dispute a debt is by saying that, by alleging that a part of that debt has been paid. For instance, now I will differentiate these instances after mentioning them. But like I said, a part of the debt has been paid off. For example, the creditor is alleging 1 million naira. Now, the debtor is not saying that he was never owing 1 million naira in the first place. However, he is saying that part of that 1 million naira has been paid already. So it's remaining another part of it to be paid off. Now, another instance for disputing or challenging the debt is in terms of saying that the debt has been paid. Now, this is a very rare instance, but sometimes that may be the case. For example, let me even use this basic instance of where someone, you know how we all know the bank situation in the country right now, where someone sends money today and you receive a lot in the next 2 weeks. That can apply here, where the debtor has sent the money. However, the creditor is yet to receive a lot of this money. And obviously, if he hasn't received a lot, he has no way to confirm, or he cannot change his records. So in that instance, while the creditor is still thinking that he's being owed, the debtor who has cleared his debt or who has sent the money will be relaxed, feeling that all is well, not knowing that there's a mix-up somewhere. So the last point or last instance or last point for challenging a debt is by saying that there was no debt in the first place. Now, the first point of challenge is that the amount alleged to be owed by the creditor is different from the amount the debtor thinks he is owing. Number two, for the amount alleged by the creditor, the debtor himself alleges that yes, so that was the initial amount being owed. However, a part of it has been paid. The third instance is that while the creditor still thinks that he's being owed, the debtor had paid up his debts. And in some instances, in addition to the whole bank issue that I mentioned, which can be far-fetched, sometimes many creditors don't update their records. So while truly the debtor has actually paid up his debt, the creditor is yet to reflect that payment and to remove the name from the debt profile. So anyone who picks it up would obviously still think that the debtor is owing. So obviously, if the debtor has paid up his debt, all he needs to do is to show a proof of payment, and that's it. Now, the fourth instance is simply where the debtor is saying simpliciter that he's owing no money. Obviously, this issue of disputing debts is very controversial, and most times can be very, it can be very nasty, if I may use that word. And many a times they end up, both parties end up going to court, venturing into litigation to sort out their issue. However, a point to note here is, if a debtor wants to dispute a debt, the best thing to do is to send a notice of disputing the debt to the creditor, preferably in writing. And in addition to asking or requiring the creditor to respond as well in writing, because of records purposes. Now, the next right is this one. I should have even started with this particular right. The next right is the right to be free from harassment / right to dignity of human person / right against discrimination. One thing debtors face so much is harassment as well as discrimination for owing debt. Sometimes a debtor is even prone to violence, use of threats, and so on. Examples of such acts of harassment includes calling incessantly and indiscriminately and indefinitely, using vulgar / offensive words against the debtor, threatening assault or injury, using actual violence against the debtor, making untrue or deceptive claims, calling at inconvenient hours as late as 1 p.m. As late as 1 a.m., 12 a.m., and even revealing the fact that you are owing money to literally everyone around you. So all this, as a debtor, in as much as you are owing money, and at least you are making efforts to sort out your debts, you have the right to freedom from discrimination, right to freedom from harassment, and right to be treated as a human person. You owing debt does not in any way reduce your dignity as a person, and that point should be well taken note of. Okay, now the next right is the right to seek help. One mistake anyone owing makes is trying to hide the fact that you are in debt. Hiding the problem has never solved that problem. Please take note of what I just said. Hiding the problem has never solved that problem. Though I can understand that one of the reasons for not wanting to reveal the fact that one is in debt could be due to fear of discrimination, stigmatization that comes with owing debt. However, again, that has not in any way helped anyone. Now, one of the ways you can exercise this right is by actually reaching out to your creditor. Now, from experience again, one of the issues creditors have with debtors is not necessarily that you are owing, but your attitude while owing. For goodness sake, you cannot owe and at the same time you don't communicate, you are nowhere to be found, you are not reachable. How do you expect your creditor? Obviously, that's one of the reasons why creditors resort to self-help. I'm not saying it is good, but sometimes on your part as a debtor, you need to ensure that your hands are clean. There's this maxim in equity called, "He who comes to equity must come with clean hands." You cannot choose to exercise either of these rights I'm mentioning here when on your part, you are not making any efforts, you are not reaching out to your creditor, you are not taking the necessary steps to show zeal to clear your debt profile. You are not doing any of this and you expect the creditor to be happy about that. No one wants to be owed. So if you know that you are unable to sort out that payment for whatever reason, reach out to your creditor. Many creditors / debt recovery agencies usually have flexible debt recovery programs or profiles that can help you settle that debt. And while seeking this help, that's even an instance for you to exercise your right to negotiate. Because while you are seeking help, I remember one of the instances is to reach out to your creditor or the debt recovery agency that was engaged to recover the debt on the creditor's behalf. When you seek that help, you can use the opportunity to negotiate either reduction in the total sum or in payment plan or whatever that can basically help you sort out your issue. Another way to exercise this right is by reaching out to non-governmental organizations willing to help people in need. There are a good number of them. Christian, especially religious, let me not say Christian, religious organizations who are able to give out funds for whatever reason. They may be difficult to find, but nothing stops you from trying, because as a debtor, you owe yourself the duty to exercise every and any step, to relieve yourself of this obligation. Because so far as this debt is attached to your name, you may not be at peace, sorry to say. But that's why it's good for you to take steps yourself. Now, another way to seek out help is by asking your friends, family, and colleagues for financial aid. Things happen. So asking for help should always be an option to be exercised. Now, obviously, by this particular instance is something that many people may not necessarily be comfortable with doing. But that's why, in order to do this properly, you can help yourself by reaching out to close friends and family. Now, this is something that I hold personally as a view. Now, if I don't or we haven't been in communication for years, for a long period of time, and all of a sudden you reach out to me asking me for financial help, let's tell ourselves the truth. The tendency for me to help someone who I've been communicating with on a, I won't say daily basis, but who I've been communicating with frequently is it will definitely be higher than someone who just remembered you when he or she needed help. So my point here is when you're trying to reach out to family, friends, colleagues, it's best to reach out to those that have been in your close circle. This way, they would obviously want to reach out, assist you as much as they can. Please note that help should be sought for at the earliest possible time. Waiting for the debt to build up for a long period of time will not aid anything or anyone. Now, the next right is the right to privacy. Now, I'm going to discuss the right to privacy and the next right being right to fair debt collection practices together. Now, okay, let me even start. I'll mix them up. Let me start with the right to fair debt collection practices. Now, fair debt collection practices simply refers to the procedure for ensuring that one clears his or her debts in the most humane, ethical, or civil manner. Debt collection practices can also be referred to collecting debt based on the method or procedure acceptable and recognized under the law of the society. Now, the most common form of debt recovery under the law involves adopting any ADR mechanisms, that's alternative dispute resolution mechanisms. Some time ago, I differentiated alternative dispute resolution from from dispute resolution mechanisms. These are two different. So, by alternative dispute resolution mechanisms, what we're talking about here are other ways of resolving disputes aside litigation. So, you could adopt, like the most recognizable one under the law, generally involves negotiation, mediation, or even arbitration, basically reaching out to the debtor for amicable settlement. Now, adopting these ADR mechanisms does not necessarily mean that all would come to an end in that instance. So this leads to the next recognizable form of debt recovery under the law, and that's litigation. So now, apart from litigation, like going into litigation straight up, after ADR has been adopted, there may be instances where even the ADR may lead to litigation. One of it is where both parties are unable to reach any amicable settlement under ADR. They can go into litigation. Where either party is not even willing to, mostly the creditor is not even willing to adopt ADR, you can simply go to the court directly. Or even an instance where both the creditor and the debtor have reached a conclusion or a decision. However, one of the parties now unilaterally decides to do outside what has happened. In that instance, the other party can simply take the agreement, which has been reduced into writing, and enforce it as a form of contract under the law. Now, fair debt collection practices presupposes unfair debt recovery practices. Now, these are simply debt recovery practices that involves unfair treatment, that involves harassment, that involves violence, that involves basically any form of inhumane treatment that one can be subjected to mandate them or compel them to pay. Now, this includes seizing the goods or properties of the debtor, involving the police, which has been decided in a plethora of cases, and it's even contained in the Police Act, that the police should not be involved in any civil matter. Debt recovery is a civil matter. The police should not be involved in any civil matter, debt recovery being one of them. Now, another form of unfair debt recovery practice is broadcasting the name of the debtor to all platforms, especially the social media, with all forms of demeaning tags. You see things like so person, age this is a notorious person who has refused to, or who has absconded with the money of so company, in as much as truly the person borrowed money and is yet to pay back. The manner in which you coin these messages can backfire, because there's a way you will coin the message and it will lead to what is known as defamation under the law. Now, a defense to defamation is truth. If that publication is the truth, then the person alleging harm cannot claim defamation. However, like I said, calling me a notorious debtor who has been collecting money and owing people all over the place, and saying that I borrowed money from this particular company and have not paid, during this duration. These are two different broadcasts. The first one, you are demeaning me. You are basically saying that all I do is to gallivant and owe money, while the other publication is simply stating exactly what has happened, which is that I have borrowed money from this company and have not paid. So the way, these things happen, these things happen almost on a daily basis. I cannot count how many of such broadcasts I have received personally on people that I know that we are owing money. Now, another unfair debt recovery practice involves locating and physically harming debtors. Yes, these things happen. So now, for the part of broadcasting the name, that would come under violating your rights your right to privacy as a debtor, because you are owing the company the money. You are not owing the whole world. So, in an instance where the fact that you're owing has been sent to everybody, that's them violating your right to privacy. That's them putting your business out there, and that's basically them violating your rights. So this violating your right as a privacy will be in the form of reaching out to your employer, reaching out to your family members, reaching out to your friends and colleagues. However, reaching out to these people can only be as a last resort when attempts to reaching out to you has proved impossible. So when they've contacted you, your number is not going through, you're not responding to emails, you're not responding to any of your social media handles, they can reach out to your employer, to your friends and your family. However, the manner of the publication matters. And that's the point I'm trying to raise here. So, just to run it down again, the rights that I have mentioned here are: number one, right to negotiate the debt. Number two, right to dispute the debt. Number three, right to be free from harassment, right to dignity of human person, and right against discrimination. Number four, right to seek help. Number five, right to privacy. And number six, right to fair debt collection practices. Now, having noted all these rights, the next thing to point out, this will be a very brief summary. Next thing to point out is, how can these rights be enforced? Now, when it comes to human rights enforcement, the first thing to look out for is the law covering rights in your jurisdiction. So in Nigeria, even when we talk about rights now in Nigeria, rights enforcement, what we are looking at is fundamental rights enforcement as recognized under Chapter 4 of the 1999 of the Federal Republic of Nigeria as amended, the African Charter on Human and People's Rights, and any other human rights instrument as recognized in Nigeria. Now, the thing with enforcing any of these rights mentioned now under Chapter 4, now the procedure to do that is through the Fundamental Rights Enforcement Procedure Rules of 2009, and such applications are usually brought via originating application. Now, the issue with enforcing these rights under Chapter 4 is that when human rights enforcement in Nigeria is sui generis, that means it has its own line of procedure. So if the facts backing these violations that you are trying to enforce are not covered under Chapter 4 or any human rights instruments in Nigeria or even case law, the tendency of the courts accepting is very low. So the best thing to do would be, as much, even before you even talk about enforcing any of these rights I've mentioned, the best thing you need to do is to reach out to the nearest legal practitioner around and explain your predicament to this legal practitioner. He or she would be in the best position to explain to you how either of these rights can be enforced. However, if enforcing any of these rights under Chapter 4 will prove difficult, the best thing to do would be to sue. And now I'm talking to you as a debtor, would be to sue based on any law that has been contravened on your while you are being accosted. Let me give an example. Where you are attacked or being beaten up because you are owing money, you can simply resort to reporting to the police. Now, I said that yes, debt recovery itself is a civil matter. However, where the other party has resorted to criminal acts to, recover this debt from you as a debtor, you can report to the police that you are being assaulted. Assault and battery are offenses under the law. The lists are endless. So things like that, where your goods are seized without any order of court, you can claim trespass to goods. You can claim destiny. You can even claim enforce your rights to property under Chapter 4. So it basically depends on how the case is built up, either around Chapter 4 or any other law that has been contravened while you are being harmed. So that's the best. I just wanted to put that out there, because when you talk about rights, the next thing should be its enforcement. That's why I decided to include that subheading there. Now, please take note of these notables. Number one, in exercising either of these rights, please don't be rude. However, be assertive. Make your position known in the most honest and calm manner. Number two, in the exercise of either of these rights, the Latin maxim, like I said earlier, he who comes to equity must come with clean hands, must be adhered to. Aside owing the debt, there should be no taint on your part regarding the debt. For instance, you are owing debt, but you are evasive, you are hiding, you are running away, you are not that you don't have these funds to pay back. You are gathering your resources, you are pulling money from your account. You are literally making efforts not to pay the debts rather than doing the other way. Once you start doing things like that and you want to exercise either of these rights, the tendencies of doing so, it's very slim, because rights generally in Nigeria are not absolute. There are always exceptions to them. So the exception to these particular rights now I have mentioned is you tainting yourself by some of the fraudulent activities that you yourself as a debtor can perpetrate. So the next point is, do not ignore your debt. Always be the one to reach out first and suggest amicable settlements to your creditor. The reason why, I already stated this, but let me just read it out. The reason creditors resort to all sorts of practices could be due to the nonchalant attitude of debtors. So far as you show zeal to clear your debt, ample time will be given to you as a debtor to clear these debts. Fourth point, always update the creditor with any change in your plan or life likely to affect any agreements reached with the debtor or the creditor. Like I said, for example, now a payment plan has been structured, 100,000 naira every month for the next 10 months. And God forbid, one is involved in a car accident or fatally ill, or some emergency comes up, or an act of God comes up, and you're trying to sort out these issues. You are expected to keep your creditor in the loop. Because how else is a creditor meant to know that there's an issue without you letting him know that there is an issue? Your creditor is not a soothsayer, he's not a seer. He literally relies on any information given by you. So always make sure to update the creditor with any information that's or any happening or any event that may affect your payment plan or whatever agreement you may have reached. And avoid excuses. Giving reasons and giving excuses are two different things. A reason is basically anything. This is my own description. When a reason is given, it simply means that there was no other way to sort out that issue. That's why what happened happened. But when an excuse is given, there was an alternative to that happening, but then you sought to just let it happen. Let me give a practical example now. You will be on your way to pay the money at the bank, and maybe when you got there, there was queue. And rather than waiting, you left the queue in the name of son was flogging you or whatever. That's an excuse because you had an obligation to fulfill, and that's to make that payment. However, if we were standing on the queue and the bank closed, that's a reason. You get it? You get the difference? Reason, excuse here is you're standing on the queue is too long, you left. Reason, you were standing on the queue, however, the bank closed. Now, the point is always avoid excuses as much as you like, because basically you're trying to beckon on the conscience of your creditor. So you can't take them for granted. That's basically what I'm trying to say. So I hope I've been able to enlighten you on an aspect of this debt recovery journey that everyone needs to be aware of, both as a creditor, as a debtor, and I hope to enlighten you on subsequent issues that may arise in the course of the recovery journey. Thank you very much. I'm your host once again, Ensign Okezewozu.